The evidence of Constable Matebula, if you can just place that on record.
Yes, indeed, my lord. So the date is 16 August 2020. The highlighted portion for Mr. Matebula reads as follows, my lord. At 20:53, we are at the police station detaining. Whilst at the police station, we received a complaint via radio control, which was a shooting in progress in number 13511 Kutwanong Street, Mzamo, Vosloorus. And the next page, my lord, with the same date of 16 August 2023, Mr. Mtetwa, when the complaint came through, we stopped everything and we rushed to that shooting in progress. Mr. Mtetwa further says, when we got to that street, we saw people standing outside. Mr. Mtetwa again, a certain lady with just a body, but she is a lady, waved to us and pointed to a particular direction.
Thank you. Now, what is your comment?
My lord, it confirms what I've said earlier, that as I was trying to, right at the beginning, when I was trying to establish as to whether there were intruders or none at the preliminary stage of the analysis of this docket, this is one of the aspects that I looked at, and that is the first responding officers being informed that there was a shooting in progress, and the suspects, in his contained statement, ran towards that direction, which is basically the park. So for me, the fact that the first responders, police officers, were informed clearly that the people who were involved in that shooting ran to a certain direction. It's a clear indication that there were people who were involved and they ran to a certain direction, and they were not found on that day, my lord. And this, my lord, as I've said, is in addition to the neighbors, the witnesses who witnessed people running out of that house after the shooting. So taking that information, which was disposed in the form of a statement, I couldn't ignore the fact that the only inclination or direction is that indeed there were intruders, because this is independent from the people who were inside the house, who were then questionable at that stage that perhaps were they telling the truth or not. These are independent people. These are police officers who were in duty, who simply responded to the crime scene, my lord, and this is what they were informed. They documented what they were informed. They had no reason to mislead. And the neighbors and the people who also indicated that they saw people running to a certain direction, they were not part of the people who were inside the house. Those were simply eyewitnesses and neighbors who simply indicated what they observed, my lord.
You said neighbors. There was a neighbor you said in the evidence. They say that neighbor passed away. It's Mr.
Nasha. Yes, yeah, the senior.
The senior. Was he a policeman or what?
He was a warrant officer, was a police officer, yes, and then he retired warrant officer, yes. He disposed an affidavit, and also the same indication was given, my lord. And my lord, further one can say that in dissecting this, because at that stage it was almost like a fact-finding mission for me, because you see with this matter there are sort of two, you have obviously what is contained in the docket, but there seems to be this theory or assertion or allegations, if I can put it that way, that there were no intruders. One needed to dissect what was contained in the docket factually, not on allegations or theories, on hearsay, on the facts that were contained in the docket. And the facts contained in the docket, my lord, indicate what I've informed the court, that there were independent witnesses other than the people who were in the house who saw people running out of that house. No one could say that the people who ran out of the house were actually the same people who were in the house. They ran, a description is given by the neighbors who were outside. That description, particularly of one of the shooters with the dreadlocks, is also given by the people who were inside the house. So there you find a common factor that there was a person described with a firearm inside the house with dreadlocks. The neighbors, particularly the lady that was sitting outside, I recall that saying she saw when they were running away that one of the suspects had dreadlocks. Now, you have to take that objectively, my lord, not in terms of hearsay, objectively. In addition to that, my lord, I've said objective evidence, which is DNA, that was found at the crime scene, excluded everyone that was in the house. What it indicated is that that DNA was left by someone else other than the person who were in the house. the persons who were inside the house. That DNA was obviously at a later stage, my lord, when these accused were actually now targeted. Their DNA were taken for comparison. I suppose when we get to that stage, I will deal with it, my lord, because as much as certain findings were made by the specialist, but they were pointers by the specialist to say there are common things that you can find on these people. And for me as an investigator, it was good enough that even if it's 1 or 2% of the DNA, for example, pointing accused number 3, it is enough for me to convince me that he was there as an investigator.
Objection. That is not his terrain. It is exclusively not his terrain. He's repeating the very same thing that I cautioned about. Mr. Gininda is not here as an expert, my lord. He's here as a police officer. He only needs to bring information to the court, the basis on which this court then will have to make a decision. He is not here to analyze that information as though he's the one that is going ultimately to give a judgment. He's pretty wrong, and the state is allowing to do that. I don't know if the state is doing that with a view in order to influence the mind of the court. But I'm very grateful because the court said earlier on that the court is well trained and it is experienced enough to separate the wheat from the chaff. What Mr. Gininda is doing now is only trying to influence the mind of the court with a hell lot of a chaff. What is stating now is a chaff. It's nonsensical. It should not be done, my lord. And I'm going to request the state to tell its witness to refrain from what the state's witness is doing, my lord. Because it's not here as an expert, and we're not interested in his opinion. His opinion matters not. Ultimately, it is going to be the duty of the state, on the basis of the evidence that Mr. Gininda would have submitted to this court, to argue what he is now trying to argue. Otherwise, Mr. Baloyi needs to get into the box and Mr. Gininda come into the point where Mr. Baloyi is standing. They need to swap positions. But what he's doing now is pretty nonsensical, my lord.
Okay, yes, let's hear the state. What's the state's
As a good please, my lord, I think very fresh on the article that the court referred to about courtesy in court, one would have expected Advocate Mnisi to refrain from using words such as nonsensical, no matter how strongly he might object to the evidence. I think there's still a duty to show courtesy to the witness and the court. That is the first thing. The second thing is the court had asked this witness a question in elucidation, and the witness was in the process of answering the question that was posed by the court. And thirdly, as Advocate Mnisi pointed out, that the court has mentioned that it's trained to separate evidence from opinion evidence. Thank you. The state will request that those gratuitous and unbridled insults by Advocate Mnisi regarding the witness be ignored, my lord.
It is no insult. The word nonsensical is there in the dictionary. If Mr. Baloyi is not aware of it, I can refer him to that word. And the definition of that word simply means that it makes no sense. It is nonsensical. I don't know how insulting that word is, man. And Mr. Baloyi has been allowing Mr. Gininda to give opinion evidence. Mr. Baloyi has allowed this witness on a number of occasions to come up with suggestion that the evidence that is already before court demonstrated that accused number 3 was involved in this matter. He now mentions DNA. Previously, he also mentioned a firearm. It consistently allows this witness, my lord, to go on an escapade on evidence that it's, at this stage it is inadmissible. It's basically giving this witness a role that he himself should actually be playing. For instance, the court has simply asked a question about Mr. Ngachi, whether or not he was still alive or what. This witness now goes out of the rail. It goes out of the question that the court has specifically asked. And Mr. Baloyi allows that to happen. And then he stands up and says there's an article that has been written by the honorable judges of this court on how ethics is. I am not here, my lord, representing myself. I am here to represent the interest of accused number 3. And I cannot allow witness such as evidence such as the one that is coming from Mr. Gininda to go through the record and sit it down here. I'll never allow that, my lord. Otherwise, I'll be doing injustice in the representation of Mr. Mncube here. But first and foremost, it starts with Mr. Baloyi himself. Okay. Thank you, my lord.
When the court asks this witness to comment on something, we cannot interrupt the witness when he answers to a question that was answered by the court and to which the court is entitled to ask. That is the simple fact of the matter. And as we pointed out, my lord, we don't understand the objection that was raised by Advocate Mnisi. As the court pleases.